All rise. First District Court of Appeal is now in session. All who have business before this court draw near, give attention, and shall be heard. May God save these United States, the great state of Florida, and this honorable court.
Please be seated. Good morning and welcome to the First District Court of Appeal. We have two cases on the docket this morning. The first one is Rebecca Dickey versus Winn-Dixie Stores et al. Mr. Martinborough, are you ready to proceed?
I am, Your Honor.
Okay, then you may proceed.
Thank you. May it please the court, my name is Hal Martinborough, and I have the pleasure of representing Rebecca Dickey along with Alan McConaughey of the Bonneville Lewis firm.
Are you going to reserve any time?
I am, Your Honor. I'm going to reserve 4 minutes.
4 minutes, okay, great.
And I'd already informed the clerk. Thank you.
Okay, well, you're responsible for keeping track of that. But
I will.
I will remind you if I think about it, but I can't promise it.
I've got these fancy lights right here.
Okay.
I'll keep up, Your Honor. Thank you very much.
Okay.
Again, may it please the court. We're here today about a summary judgment that had been entered against Ms. Dickey arising out of a fall that she had at a Winn-Dixie store here in Tallahassee. We believe that that summary judgment is an error and that this court should reverse it. Ms. Dickey went to this Winn-Dixie several years ago, got out of her car, walked toward the store. As she walked toward the store, she approached, obviously, what we see in all parking lots. She saw striping that marked crosswalks. She saw colors. She saw yellow coloring that was on some curbs. She saw yellow coloring that was on ramps that were leading up into the Winn-Dixie. And she saw this pretty much all over as she approached the store. The evidence here shows that she walked into the store up the ramp. So this is an important factor. She walked up a ramp that was colored yellow. There was no curb. There was no change in height. It was a smooth rising ramp when she went up it. She went up was going up into the store, and unfortunately she was unable to get some of the carts separated, or she wasn't able to find a cart, and she went to go back out into the parking lot. When she went back toward the parking lot, she walked out a different way. She walked out, instead of going right down the ramp, she went off to the side, and this is all on video in the record. She went off and she stepped, essentially you can see on the video, she stepped on the curb and then fell, and she was injured. She filed a lawsuit alleging that the combination of, well, I'm not sure it was alleged this specifically in the complaint, but the theory that was developed in the case below was that...
my understanding is when Judge, was it Dempsey, granted summary judgment, she did so on the basis that the hazard was open and obvious, right?
Absolutely, Your Honor. And that's the central point of this case,
Okay.
is does this particular condition fall into the open and obvious category of cases that have allowed summary judgment or directed verdict in some cases involving curbs? The real question here is, was this curb similar to the curbs that were in the cases that were cited by Winn-Dixie?
Well, my understanding of your argument is that you've alleged there's two duties to
Yes.
the business invitees. One is warn of dangerous conditions, which
Yes.
may or may not,
Right.
be discharged by the fact that it's open and notorious. And the other is duty to maintain, which my understanding is your contention is that is not discharged by the fact that it's an open condition. Is that an accurate description?
I want to make sure I answer that properly in light of what the cases say. The cases do say that some curbs can be open and obvious conditions that are so open and obvious as to expect that citizens will know that they're there and pay attention to them and look where they're walking, and we're not going to allow for there to be liability about those. The difference between, and there's 3 cases that are cited by Winn-Dixie, and they're the common cases, and they all deal with a similar situation. They all deal with curbs that are not marked and claims that they should have been marked. So in some of those cases, their argument has been, well, you should make it yellow, or you should make it white, or you should do something to set off the curb from the street. And the courts have said, well, you don't really have to do that because curbs are curbs, and people know that we have curbs, and curbs aren't always colored, and you just have to pay attention to the fact that they exist.
But these curbs were colored.
These were colored, Your Honor, and if they were only colored, this wouldn't be before you right now. If the only thing that was out there was yellow coloring on the curbs, then this would not be a reasonable case. If it was only a non-colored curb and a regular curb, we wouldn't be here today. The problem here is twofold. Number one, the curb isn't truly a curb. You can see from the record that normally curbs are going to be.
And that's something I was having a hard time understanding. It seems like part of your argument was that a 2.5-inch curb was perhaps more dangerous than a 6-inch curb.
Absolutely.
So if you'd explain a little bit more.
Absolutely, absolutely. So when we see a curb, we think of a couple of different things. You think of how high you may fall and things like that, and that would seem kind of commonsensically to mean you would fall further. Stepping down 6 inches, you may roll your ankle, something's going to happen. The injury itself is probably not going to be worse either way. The noticeability is really what I'm talking about here, Your Honor. When you deal with a 6-inch curb, especially if it's not colored in a way that mixes it up with other areas that don't have a curb, a 6-inch curb is real easy to see, or a 4-inch curb is real easy to see. The smaller and smaller you get, one of the problems isn't that you're going to fall too far, it's that the less of a curb there is, the less noticeable it is. So when you have Ms. Dickey leaving the Winn-Dixie and she's walking toward that area, she sees yellow, but of course she just went up yellow, and there was no ramp. There was no curb. It was on a ramp. There was no change in elevation, or not an abrupt one. Now she's walking out a different area, and because this is, and the reason doesn't matter, because Winn-Dixie controls this and is responsible for it, but as this curb has gone from 4 to 6 inches all the way down to 2.5 inches, it's a lot less easy for somebody as they're approaching it to see that change in distance, and see that change in height. And that change in height is what alerts us to be careful about curbs.
Yeah. Well, I've watched the video several times.
Okay.
And it seems to me it's fairly obvious that Ms. Dickey is not looking down. She's looking out to the parking lot. I guess to avoid traffic. So,
absolutely.
So how does the noticeability doesn't seem to be a factor because she was not looking down at all?
Well, so the interesting thing about these things is we all get together and we try to do a hindsight analysis of something that took 4 or 5 seconds,
Sure, yeah.
or that's a complete.
Well, that's kind of what we do here, unfortunately. Yeah,
it is, no doubt. But I'm just trying to put it in perspective. Again, you've got to be paying some attention. But Winn-Dixie also has to know people are looking at the parking lot, that they're looking at the traffic, that they're looking at those kind of things. Because you're looking out, and this is a very difficult thing, it doesn't mean that people aren't tracking what's in front of them also.
Okay.
I mean, and again, I don't want to get over, I'm not an expert, but the reality of how people is we approach situations and we address all the dangers, all the different things that we face in instantaneous decisions. And one of those things that we're doing all the time is looking at changes in heights and things that you're paying attention to. And again, one of our biggest issues here is, had this been a normal curb and she hadn't just gone up a yellow thing that didn't have a curb, this may not be as big of an issue. I do think that the 2.5-inch curb alone creates enough, at least for this to be a jury question, maybe a hard jury question.
It seems to me an important part of your argument is that the curb was painted yellow, but also the asphalt adjacent to the curb was also painted yellow.
Right.
And that might have caused
and it certainly
some depth perception issues, right?
The best way to put it is the way that her expert, Mr. Bryant, said. He said when all this is all going on, it camouflages the actual curb.
Okay.
And that's really what this is about, is this case just a curb case? And I understand that's exactly how Winn-Dixie should argue. This is just a curb case. We've got a bunch of curb cases, just to grant summary judgment.
Yeah, those are out there in the world, and we should know about them.
Exactly.
Yeah.
And if those cases apply and this is a regular curb, I don't have a very good faith argument to make for you here. But I do have a good faith argument here to make for you, because it's not just about that. It is about the coloring. I can't get away from the fact that it's the fact that she had just gone up a step, or not up a step, but up a ramp to change, and then she's going back a different way. And you can see this in the, I've got to remember which, in the Hilliard versus the Speedway supermarket case, where somebody was actually in like a gas station mini mart kind of scenario, and actually stepped up onto a curb, up onto a step to go into the little store to pay. And when they came out, they stepped and didn't notice it and fell and got hurt. And the 4th DCA said, that's just a curb. But she had an expert who said, when you have this kind of situation, when you have these other distractions, when you have this other stuff going on, there should be some kind of marking. Now, he was saying there should be a marking. So he was even adding another aspect to it. We're here dealing with the fact that our client had to face 2 different areas of travel that were different but colored the same. One of the best ways to look at this is just kind of maybe step over and look at the warning lines of cases. Where you talk about, is there overwarning, is there underwarning, is there confusing warning? That's what these signals are. This isn't a curb case, it's a warning case. It's a signal case. And I don't mean warning in the sense of warning dangerous drop. I mean, they create a whole scenario of warning saying, be careful here, this is going to be this. Here, yellow means flat. Here, yellow means curb, but it doesn't even mean curb because the curb is 2.5 inches. It's not 4 inches. It's not 6 inches. And you're not going to be able to see it in your normal expectation of processing information as you're traveling around. And I cited a number of cases for the court in the briefs and in the reply brief, but talking about the courts have recognized if there are distractions to these things, then they're not ordinary curb cases. Whether it's somebody buying clothes in a store and a rack, being maintained at eye level, but the floor changing, somebody's looking here rather than there.
So, Counselor, your expert had stated that there were standards that were not being met, and my recollection is Judge Dempsey had said that, they haven't proven that those standards apply in this case. So you can say all you want that, it would have been better if the curb had been painted this color and the ramp this color and whatnot. But my understanding of the finding of the trial judge is that they said that, look, none of these suggestions are standards that apply in this case, and because they're not, they can't form the basis of a negligence claim.
Well, first, that would not be an accurate statement of the law, and I'm working into my rebuttal, but that's okay.
Please answer the question.
Yeah, absolutely, absolutely. And I'd rather get this answered than have the rebuttal time. There are two issues there that you're bringing up there. One is, are there standards that are so controlling as to create basically the do-to-it situation, where you've got the violation of a code, and so as a matter of law, it's at least a jury question. That's not that. We do think that there are codes that apply, and he testified as to which ones, and he talked about the MUCTD and things like that, and how the paint should be. But that's different than whether or not he can rely on the different standards and how you're supposed to use these signals and how you're supposed to use the warnings. And he absolutely testified, along with those standards, that even with all of those, that when somebody's designing that, you're supposed to set it up so that you don't have all these confusing markings and that people can recognize certain colors mean certain things as opposed to meaning multiple things. And he also talked about that curb height being a problem along with it. So this there does not have to be a finding that there's a specific code that was violated here or that applied here for us to win. I think it does exist. I think due-to-it applies. But I think the easier way for this court is to simply address the fact that you have these multiple conflicting signals being given to her, and you've got a curb that doesn't really show her, and that's at least enough for a jury to evaluate as to whether or not that's a negligent condition. And I'll save the rest of my time for my rebuttal if there are no other questions.
Madam Clerk, will you give both sides an extra minute, please?
Thank you.
Thank you, Your Honors, and may it please the Court. Eleanor Sills on behalf of Winn-Dixie and Smith General Interest Partnerships. I'm joined today by my co-counsel, Chris Altenburn. This Court should affirm the trial court's grant of summary judgment because the curb in this case was an ordinary and innocuous curb that could not be dangerous as a matter of law. In addition, the trial court properly determined that the regulations that Mr. Bryant relied on were not applicable to this case. And there are a couple of different things in the record I want to point out to this Court that was just discussed by my friend on the other side. First, the ramp area where Ms. Dickey walked up originally was not painted yellow, and it was not striped where she originally walked. And you can see this in the picture on page 7 of the answer brief. She was walking up what was a concrete slab, and so that was not painted yellow. While there was yellow paint in the area, that specifically was not painted yellow. In addition, on page 102 of the record, Ms. Dickey did testify that she stepped down and then she fell. That shows that she understood that there was a change in elevation in the area. And she additionally testified that yellow signifies caution, and she understood that that was supposed to show her that it was caution, or she was to use caution in that area. Moreover,
so what are we to make of the fact that while the curb was yellow, the asphalt below the 2.5 inches down the step was also yellow and made it hard to identify?
Your Honor, I think that goes into the cases that talk about the optical illusion or the same coloring, which courts across the state have held were not dangerous as a matter of law. And simply because something is the same color doesn't mean that it is dangerous, right? And so The curb itself, yes, was painted yellow, and there was striping in the area, but there was also contrast with the asphalt, right? The asphalt was black and the striping was yellow, and then the curb was also painted yellow, but there was nothing that was the same color like we would see in other cases, Corin, Aventure Mall, things like that, where the optical illusion of flatness was the issue in those cases. And so I also want to address the 5th District's recent opinion of Jackson versus Florida Department of Transportation that was filed as notice of supplemental authority on October 10th. And in that case, the 5th District considered a very similar issue. There, the plaintiff was walking over a sidewalk that had a small change in the sidewalk, and there was also expert testimony about the applicability of the Florida Building Code to that sidewalk area. And the 5th District determined that, yes, the trial court was correct in saying that the sidewalk was an ordinary and innocuous condition that could not be actionable as a matter of law. And in addition, the expert testimony about this applicability of the Florida Building Code that was stretched a little too far, in the 5th District's opinion, did not render it a dangerous condition and did not make it where summary judgment needed to be reversed in that case. And so I would submit to this court that this is a persuasive case and it's very similar to this one, and this court should follow Jackson. Now, in regards to some of the questions about the open and obvious doctrine and how it discharges, obviously we agree that sometimes the open and obvious doctrine only discharges the duty to warn. And now there's no allegation of duty to warn in this case, but it's almost an exception or a building upon of the open and obvious doctrine where something is an ordinary and innocuous condition that then renders it where it can never be inherently dangerous or dangerous for a premises liability case. And this curb is just like the other cases that say that. And I would read to this court the 3rd District's statement in Aventura Mall that says, to hold an ordinary sidewalk curb without more is an inherently dangerous condition would make every municipality and business establishment the virtual insurer of safety of every pedestrian. And that's exactly what Ms. Dickey is asking this court to do in this case. This is just an ordinary curb. These are very commonplace conditions that we encounter in everyday life, and it's just something that cannot be actionable without more. And the without more, I think what Ms. Dickey tries to incorporate is the experts' opinions on these regulations. And I think the trial court properly determined that these were not applicable. Specifically, there were 2 regulations that her expert relied upon. The first was the traffic code, is what I'll call it. And during his deposition, he actually pulled up the FAQs for the traffic code, which said they do not apply to private parking lots. And so this is a private parking lot, that's not disputed, and her expert essentially admitted that, and there's nothing on the face of the trial court's order because there's no summary judgment transcript, and the codes were never filed with the trial court to show that that was...
Is that really necessary to survive summary judgment, that there be some sort of building code or a code that suggests that this is improper, therefore it is negligence? In other words, is there any kind of a failure to maintain or failure to warn without there being some kind of code that says so? I understand the judge's point that, well, these codes don't apply, but why is that necessary to defeat summary judgment?
Your Honor, I don't think it's necessary to defeat summary judgment. I think that curbs in a trial court can determine that they're ordinary and innocuous and that they discharge both the duty to maintain and the duty to warn. And I think that's what happened in this case. And I think that the trial court did go ahead and address the expert allegations or the violations just because that was something that had come up throughout the case. But no, I don't think that that's necessary for the summary judgment to be granted. And so I would also just point to the court that the accessibility codes that were also relied on are not applicable here because it was not a means of ingress and egress. And so specifically, I do want to just briefly mention Gorin and Rosenfeld. Both of those cases are very similar. Gorin was the 5th District case that was en banc. A plaintiff tripped over a curb that was similar colored to the sidewalk, and it was in a tourist area, it seemed, and so the patrons were really excited, and there was some expert testimony as well that there was an optical illusion of flatness. And I think that that's really the heart of this case. And the 5th District en banc said, no, it doesn't matter that there's an optical illusion of flatness. This is just simply not a dangerous condition as a matter of law. And so then the other one, Rosenfeld, that's also a 5th District case, and that happened in Magic Kingdom, and there were similar colored sidewalks in that area, and the plaintiff also fell. And again, the 5th District confirmed that ordinary changes in elevation, allegations of optical illusion simply do not, one, overcome the old summary judgment standard, and 2, do not make it actionable as a matter of law. And so, Your Honors, in a case where there's just no similar accidents, where it's a normal curb, where it's just painted normally, and where Ms. Dickey specifically testified that she was stepping down, There's nothing that she said that she was confused or that it looked odd to her. I believe that the trial court properly granted summary judgment. And if this court has no further questions. Thank you.
Very briefly, I've got just a few points to make. First, the claim that Ms. Dickey said that she stepped and fell down does not mean that she had appreciated that there was a curb there. She's describing the reality of what happened. She stepped and she put her foot out and she ended up falling. I think what's important about this is, unlike situations where you only have to rely on testimony, you have the actual video here, and you can see where she missteps on the curb, and that's what makes her fall. So that seems to suggest that she did not see that that was where the curb was going to be, and that she thought that was an area she could walk on. As Judge Roberts had noted, part of that is probably because of the design of this, where they've got this entire box that I'm not sure what it's supposed to mean out in the road, where they've got a stripe that covers the curb and goes onto the sidewalk, and goes into the asphalt, and then has diagonal lines, and then has yet another parallel line to the one that goes along the curb in the middle of the parking lot. Again, walking out, somebody seeing a line out there and a line here can think those are the same thing. There's no reason for her to have understood that that was going to be something different. The fact that there have been no similar accidents reported really shouldn't mean a lot here. For all we know, people have twisted their ankles and not made claims there over and over again. Nobody knows either way, so the fact that there's not been a claim shouldn't matter there. And finally, with respect to the Jackson versus the FDOT case, that is a newer case. I don't think that court got it right when they seemed to suggest that there had to be some kind of code violation or some kind of code that would apply for it to work. As the Speedway case, the Hilliard versus Speedway case shows, that's not the only thing. The experts can also look at the surrounding factors and determine what's the most safe. And here it's very clear in the record. Mr. Bryant testified that the combined nature of the shortened curb and the way that the colors were used here created a camouflage that curb. It created an optical illusion. This is the without more that's talked about in Aventura, and this court should reverse the summary judgment. Thank you.
Thank you both for your argument. We will give you a few minutes to clear out, and we'll allow the next group to come forward. Both of you got your papers arranged and your water all set?
Yes, sir.
Okay. Mr. Newman, you may proceed. The next case, I'll call it, is Brandon Moore versus State of Florida, and it is 240065. Mr. Newman.
Good morning, and may it please the court. My name is Luke Newman. I represent the appellant this morning. I'd like to reserve 4 minutes of my time for rebuttal, if I could. Your Honors, my client, Mr. Moore, comes to this court asking that his case be resolved in the same manner this court, a different panel obviously, decided about 8 years ago in a case called Falk versus State. In that case, this court, obviously a different panel, issued a decision in which it was deemed fundamental error to have a burglary jury instructed in a manner which omitted the third element of burglary, the affirmative defense of either a licensed or an invited entry. So essentially burglary, if I step back for a minute, is crossing the threshold of whatever the premises are, be it a vehicle, or which we call a conveyance in burglary law, or a structure, a home, with the intent to commit an offense therein.
Mr. Newman, let me ask you a question. Let's
Yes, sir.
suppose you call me up, invite me over to watch the game,
Sure.
and I say to myself, I'm going to come over and I'm going to get that jar of pennies that he's got on his mantelpiece. So I come over, you invite me in. I don't actually have to commit the crime for it to be burglary, right?
You
Just the
invite me,
intent.
I'm sorry,
No,
Judge.
no. Maybe I shouldn't use first person, second person, but if I'm invited
Yes, sir.
to a place
Yes, sir.
and I say to myself, when I get there, I will be stealing something.
Yes, sir.
There's a jar of pennies that I really want. And then I knock on the door, and I'm invited in.
Yes, sir.
Have I committed burglary?
I would say no. I'd say
Why not?
because you committed a theft, but the entry.
No, I didn't steal anything. Maybe my.
Oh,
my
I'm sorry.
Maybe my hypothetical's bad. My point is, if I enter a premises
Yes, sir.
with the intent to steal,
Yes,
but
sir.
I was invited to do so,
Yes, sir.
have I committed burglary?
No, sir.
Why not?
Because the entry has to be either an invitee or a licensee.
Okay. Is that one of the elements of the crime?
It's one of the elements of.
My
the-
understanding is there are two elements of the crime, and then there is an affirmative defense, which
Correct.
is at issue here. But my concern is, how is it that if I'm invited to come in,
Right.
that it could ever be burglary? In other words, why is it not sort of implied in element one that there's an entry to the structure, that it is an uninvited entry?
Maybe I don't follow the question, sir. I think I agree with you, though. I think agree with
Yeah.
I think I agree with the first part,
Yeah,
certainly.
It does seem like part of the problem is that the statute strongly implies, that the entry has to be a trespass of some sort.
Yeah, like if I go to Governor Square.
Correct.
And I go in a store and I steal a T-shirt.
Correct.
I've committed theft and not burglary.
I agree
right?
with that.
Okay.
I agree with that. Yeah, I don't.
Because it was a store, they welcomed me in there when they thought I was there to buy the T-shirt.
Maybe I'm saying I agree with that in
Yeah.
a hesitant nature because I'm hesitant to agree with a ton, but I tend to agree with that.
Yeah, it's just that it's listed as an affirmative defense.
I agree.
You know, you've got these two elements in the instruction, and then
Correct.
later there's this third, which used to be called a third element, is now they've specified that, no, we mean it's an affirmative defense.
I agree with that.
But I don't see how it's an affirmative defense. It seems to be part of the crime of burglary.
But it's an affirmative defense because the Supreme Court has told us it's an affirmative defense.
And when we talk about the jury instruction, I think we can agree we're talking about 13.1, the
Yes.
burglary instruction.
That's correct.
So I don't think that was something that was briefed or argued in the appeal, but I agree if Judge Winiger, if you're saying, I have problems with this being a third element, or an affirmative defense, then that's an interesting argument, but I don't think that was, I don't know if that's, maybe I can relate to maybe a feeling of hesitancy there. I mean, the 13.1 says what it says, and Fox says what it says, and so maybe.
Understood. So, along the same lines of another separate question for you, my understanding, and I'll be asking the state about the same thing, is that the state did argue that the entry was stealthy. So they argued it.
Correct.
Okay. And part of the stealthy, which I guess that infers that the entry was for the purpose of committing a crime?
Well, with the stealthy entry,
Right.
it says that if you agree that the entry was made, somebody sneaks into the
Right,
back.
that there's an inference that it was for the purpose of committing a crime. So part of the stealthy entry instruction is explicitly that it is without the consent of the owner. And that was instructed to the jury, and that was argued by the state.
I agree with that.
So considering that we're judging this case to whether the fundamental error actually occurred, does it matter that the jury it was told to the jury, both in instructions and by the state's argument, that the entry was stealthy and that it was without consent?
So I refer to that, to what you're referring to, the part of 13.1 is the stealthy entry instruction. And so I guess what you're asking me is and I agree that it was read to the jurors, and I agree that it was part of the state's closing argument in the case. So I guess what you're asking me is, could the stealthy entry instruction have, I don't know, for lack of a better term, cured the issue with not reading the affirmative defense portion
More
of
or
the
less,
instruction?
in as much as the problem was, this is fundamental error if the
Correct.
jury was unaware, because they were not instructed.
Correct.
That consent is an affirmative defense, that his consent to entry would have been affirmative defense, he was deprived of his only defense, et cetera, et cetera.
Correct.
But that by reading this instruction to the jury, that the jury at least was aware that consent was part of whether or not, the consent was part of the case. That, in other words,
Oh, well,
the state argued that entry was stealthy and that it was without consent of the owner. That's in the stealthy entry instruction. So they were at least told that the state's argument is that it is without consent.
Well,
Does that make a difference?
I would say no, but part of it I agree with completely, again, hesitantly agree with what we're talking about here is that the jury was definitely told that because the defense counsel got up and said he entered with rightful authority. And so the jury was definitely told that. And the problem was that the client had gotten up and testified that he had entered, he'd entered to commit a crime inside, but he was invited or licensed to enter by the occupant. And then, despite being told rightful authority, despite being told that the case is about consent, the affirmative defense, the actual language that the jurors could look at and say, oh, aha, if we believe that, look, he's not guilty of burglary, that was omitted. And so then, obviously, in ground one, I'm arguing that that's fundamental error, which I think at the end of the day, and it's on the trial court to ensure that the jurors are properly instructed, okay? And then in ground two, I'm arguing it as Falk instructed me to argue it by saying it's also ineffective assistance of counsel on the face of the record, that you can't have your client get up on the witness stand.
Doesn't Steiger say that you can't have ineffective assistance on the face of the record unless it's fundamental error?
I agree with that. And then Falk, and so my response to that is that Falk says it's both. Falk says both. So I'm not suggesting.
Well, Falk comes before Steiger, doesn't it?
Right, but I agree, but Falk says that it's both fundamental error and it's ineffective assistance of counsel on the face of the record. From this court 8 years ago.
So it's it's fundamental error if the trial was fundamentally unfair. Is that correct?
I agree with
Okay.
that.
So my concern is, do you think that given these matters, that the jury was, you said yourself that their argument was that he was invited.
Correct.
That there is evidence that consent of the owner was part of, at least the stealthy entry part of burglary, that the jury was aware that if your client had been consent to enter, then it wasn't a burglary.
I disagree with that.
Were they aware of that?
I disagree with that.
Okay. No,
And if they were aware of that premise, if they were aware of that theme and arguments from closings and so on, then they didn't have the tools in the jury instructions provided by the judge to vote in my client's favor.
Right. So they were not properly instructed that consent was a defense.
That's ground one, yes, sir. And sir, I lay it on the trial court's feet in ground one, and I lay it on defense counsel's feet in ground two. Let me talk about in Falk, because there's this theme in my colleague's briefing from the state that, well, this may have been, that my client's testimony may have been so unbelievable, so weak, so insubstantial as to permit this court to overlook it. I want to talk about, in Falk, if the person who allegedly got battered and burglarized in Falk just drove off into the night, that's not reflected in the decision there. If the crime scene in Falk had been washed, any weapon, there wasn't a weapon, I don't believe in Falk, had been cleaned before police got a hold of it, that's not reflected in that decision there. In this case, in Mr. Moore's case, at least part of his testimony was then corroborated by a law enforcement officer who they called. My client, when he was presenting his case in chief as a defendant, relied on body-worn camera footage, which showed his injuries, which were serious, life-threatening. I think the term that was used in trial was when he was recovered from the roadway by police officers later that night. He was half dead. He'd been seriously stabbed. The other thing I've asked this court to focus on in looking at this is if you look at the trial testimony of the alleged victim in this case, whose name was Mr. Rodriguez. He talks about my client, Mr. Moore, coming into the 18-wheeler, the cab of the 18-wheeler, and battering him, hitting him with a hammer. If you look at the verdict form, and I'll wrap up here briefly, if you look at the verdict form, the jurors found that the battery hadn't occurred. So it's not as if the jurors accepted a hook, line, and sinker everything that Mr. Rodriguez had testified to. Also in Falk, there was a jury question that I think some courts that have analyzed Falk have relied on as persuasive. In this case, there was a jury question where the jurors asked whether there's any more videos showing my client exiting specifically the cab of the 18-wheeler. So I see him into my rebuttal time. There's no questions, I'll yield.
May it please the court, my name is Adam Wilson and I represent the state of Florida in this case. We're asking that you affirm appellant's judgment and sentence at least as to one of the burglary counts and the aggravated assault count. I believe the first issue, the question is whether the trial court's failure to request a jury instruction was fundamental error, and the Supreme Court's already answered this question. When you have a defense, the failure to request a jury instruction on that defense is not fundamental error. That was in 1993 in Socor.
Isn't Socor, Socor, my recollection of Socor is it's a voluntary intoxication defense.
That's correct.
And they didn't ask for the defense, and the Supreme Court did not reverse based on the fact that the defense was given. But if it had been given, the state would not have been required to disprove voluntary intoxication. So there's really kind of a no harm, no foul for the failure to give the instruction, whereas here, the state would have been obligated to prove that there was no consent to the entry. So I see that as significantly different than what happened in Socor. And plus, we've got a lot of cases that say when you deprive a defendant of their only defense in the case, that it's fundamental error.
But, well, those cases come from Martinez, which relates to an erroneous instruction. Martinez, it was the
So it
forcible-
doesn't apply at all to a omission of instruction?
No, and that's the express holding of the 5th DCA in Muhammad, which I cited in the brief, is that there's two separate situations. You have the failure to give an instruction and giving an instruction that is erroneous. And it kind of makes sense that you would have different standards for those two situations, because when you give an erroneous instruction, the jury is told you can't do self-defense. In Martinez, the jury self-defense was pretty much taken off the table by the confusing jury instruction. Here, consent was never taken off the table as a defense. In fact, both parties actually agreed that consent was a defense. As you noted, the stealthy entrance instruction kind of primed the jury for the idea that the entrance had to be unlawful. The jury was also given a permission instruction that's contained within the trespass, the standard instruction for trespass. But
The state's argument in this case was not that the defendant did not have consent to enter the truck. I didn't see that anywhere in the closing
Look in
argument.
the state's rebuttal. In a rebuttal argument, the prosecutor says something to the effect of, the only way you're going to get reasonable doubt is if you believe his story, which is that he had consent to enter the truck.
Yeah, so basically the way they tried to prove their case was not by establishing that all of the elements of the offense were proven beyond a reasonable doubt, but that they just shouldn't believe the defense's story. The defense tells a ridiculous story, and therefore you should convict.
No, I think
Which may be a problem in and of itself, but that wasn't an issue in this case. But
No, I think
I never heard them say he did not have consent to enter. I did not hear the prosecutor say that.
She said, I guess she did not say the word, he did not have consent to enter. But I think the rebuttal argument clearly identifies or suggests that consent is an issue in this case. And the jury was in fact instructed that it is lawful to enter a conveyance if you have the permission of the owner. This was after the trespass instruction was given, but it wasn't explicitly listed or tied only to trespass.
So it wasn't just I understand the trespass instruction does have consent as an element.
Yeah.
You're
Or
saying
as
that
a-
it wasn't, that they were told that, but it wasn't explicitly relating to trespass?
At no point in the jury instructions does it say, this is only a defense to trespass and you don't consider this the
Well,
burglary.
my understanding is that the court was defining trespass to the jury.
The court goes through all the elements of all the burglary offenses and the lesser included offenses, and then it reads this instruction, which the jury could infer that instruction, which is broad enough to cover the entry into the truck for the burglary, would
So it
apply to
wasn't
burglary.
just part of the trespass instruction?
Huh? It is part of the trespass instruction, but the jury doesn't know that. And
Well,
in
why
fact,
should the
defense
jury
counsel.
presume that part of the trespass instruction also applies to the burglary instruction?
Because the jury is told that these are the instructions on your law. Here are the elements of all these offenses. And then now I'm going to talk about an affirmative defense. And that's the trespass one, which defense counsel actually cites to the jury in her argument as justifying their consent defense. She says, look, the judge told you that consent is a defense, and she cites to the page number for this trespass instruction. So for that reason, I think the jury was actually given consent as a defense. So even if SOCOR doesn't apply, the jury was still instructed that way. Plus, the Supreme Court's decision in Knight kind of reinforces SOCOR, where the Supreme Court said that properly understood, the fundamental error test for jury instructions cannot be met where there was no error in the jury instructions for the offense of conviction, and there was no claim that the evidence at trial was insufficient to support that conviction.
But isn't that exactly what the defendant's argument is that there was an error in the instruction on the offense of conviction?
No,
and
it's a
that
defense.
They did not give the affirmative defense instruction?
No, there's no error. No, he's arguing that it's an error in the affirmative defense, which isn't an element of the offense. The Supreme Court's decided that consent is an affirmative defense to burglary. It's not an element of the offense. So I think Knight further shows that SOCOR is the governing standard here. But even if Falk was good law and controlling in this case, I would say that he can't show fundamental error in this specific case. You don't just say Falk found fundamental error, so this case is also fundamental error. The evidence of consent in this case is extremely weak, almost non-existent. The defendant's never actually invited into this truck, if you read his testimony carefully. He shows up outside, starts banging on the door, yelling. Defendant gets no response. Opens the door, sticks his head in, which itself is a burglary. The victim then says, hey. At this point, the defendant's standing there, dual-wielding weapons. He's got a rifle in one hand and a hammer in the other.
Don't I remember that the defendant claimed that the victim told him, if I'm in the truck, just,
That's not it. No.
okay.
The defendant claimed that the defendant pointed to the truck. That's not an invitation. Like, the defendant claimed that he kind of asked the victim, what if you're not here in an hour, whatever it takes me to get these drugs? And the victim points to the truck. That's not an invitation to come into my truck. It's an idea, like that's probably an invitation to come knock on my truck. But even if it was an invitation, the fact that the defendant doesn't respond to the knocking and yelling suggests that any prior consent would have been withdrawn. And the victim's response to the defendant's entry is that the defendant comes in, puts down the bag of cocaine, the victim turns around, grabs a knife, and chases the victim, or the defendant, out of the truck. That suggests that he wasn't, that's consistent with someone who has an armed burglar jumping into his truck and never gave consent at all. Furthermore, in this case, both parties agreed that consent was the defense. I know you disagree with that, but I think the state's argument agreed that consent was a defense. The jury was given that trespass instruction, which said that the entry into the truck was lawful if he had permission. The stealthy entrance instruction also kind of brings up consent. And then, frankly, there's no compelling demand for application of fundamental error in this case, given the strong incentive that cases like this present to stay silent when you notice an error. In Knight, this court recognized that in the context of an erroneous jury instruction, applying fundamental error every time kind of gives counsel an incentive to just sit there silently when there's an erroneous jury instruction and keep that in their hip pocket for appeal. The same thing would seem to apply when there's no instruction at all. So for those reasons, I think even if Falk's the controlling case law, you should not find fundamental error here. And because he can't show fundamental error, he can't just attach IAC on the face of the record, or IAC claim, and get reversal on that ground. IAC is a high bar. He's got to show no conceivable strategy, indisputable prejudice, and fundamental error. I don't think he can show any of those. As this court recognized in Knight, sandbagging by remaining silent with an erroneous instruction is a viable strategy, a conceivable strategy. Indisputable prejudice in this case, he can't show that without the trial judge being able to weigh the credibility of his testimony. His story sounds
So if the
fishy.
defendant's saying that he was invited in, I'm trying to get my head around what kind of conceivable strategy would a defense counsel say, well, I'm not even gonna even ask for an instruction on that.
She asked for an instruction on the one from trespass, and then she can then argue it in this case, argue
But
consent to the
Why would it be
jury.
a strategy to not ask for it in the burglary count?
Because she can now get reversal and get another shot at this after losing this case. Because
So her strategy was to intentionally not ask for a consent instruction just in case
exactly,
she's convicted?
just like this case, this court recognized in Knight, where it suggested that there's a strategy in allowing an erroneous jury instruction to go to the jury. Seems even more likely here, where you're getting consent as a defense in a different instruction. You're getting agreement from the parties that consent is a defense. You get to argue it to the jury, and then if that doesn't work, then you get to come back again and try again with the reversible error or fundamental error. On the third issue, we agree that one of the burglary counts should be vacated, but because the defendant's a PRR, there's no need for a resentencing.
Why, with regard to the double jeopardy question, how is it that vacating one of the burglary convictions is consistent with the statute on multiple crimes, that is 775021 sub 4? It seems to me that the cases that say that, well, you can't have more than one burglary conviction if there's only one burglary and one victim,
Yeah.
they go back to a Florida Supreme Court case from 1983, Hawkins.
Yeah.
And that case was decided either right around the time of or before the statute was amended to say that any two crimes, as long as they have separate elements, offenses are separate if each offense requires proof of an element, the other does not. Why would that not apply? Instead, I know that there's cases
Yeah.
that say that, but why does that statute not apply, given that Hawkins doesn't consider the statute at all?
So the statute is basically the legislature applying the Supreme Court's Blockberger test, and I agree that both of these offenses pass that statute. The problem, in my view, is that the Supreme Court just said that these are burglary with person assaulted and burglary while armed are in fact the same offense. So that means we don't even consider Blockberger.
So even though they clearly have an element that the other does not?
Yeah, I think they're the same. At least in that view, you don't even do that test, and you just consider what the unit of prosecution is for. They're both, in that essence, burglaries. They're just burglaries with enhancements. And in that case, you look at the unit of prosecution for a burglary, which is the entry. So there was only one entry in this case, so you can only have one burglary. But without Hawkins, I think you would be right, and these would actually be separate offenses. And then on Erlinger, the Erlinger claim, we think that this was not preserved. I know there's a split among the districts on this decision, but we think the third district has it right. And even if it's preserved, in this case, it's harmless. It's a ministerial fact, and there's no real dispute. There's never been any real dispute that he qualifies, and that there are no further questions. I would ask that you affirm one of his burglary counts and the aggravated assault. Thank you.
I'd like to address a couple of issues that my colleague brought up during his oral argument just now. First of all, the SOCOR, is that how we're pronouncing it? The logic from that case is baked in to Falk itself. And so the Falk panel, when they released that decision, overtly go through the SOCOR discussion and reiterate it, and then say in that case, which is, I'd say, more factually remote than Mr. Moore's case, that it was fundamental error nonetheless. The other thing, we've talked a lot about the jury instruction 13.1 this morning. If you look at 13.1 and you where it lists the what we're calling the third element or the affirmative defense, that immediately thereafter it cites to Falk in 13.1, and it says that failure to read is fundamental error. So the idea that Falk is not good law or is not the controlling law is a new position.
So you're saying that if you fail to read this instruction, it is always fundamental error? It doesn't matter what the record says, doesn't matter what the defense, how strong the defense had been. According to this instruction, citing Falk, it is always fundamental error.
I'll read you exactly what the 13.
No, I know what it says. You don't need to read it, but do you agree with that? Or do you think that we should treat this lack of, this omission as per se fundamental error, and where we don't even have to look at the record?
Well, I mean, how I feel, how I would argue it for my client would say yes to that. But I acknowledge that there's other authority that says that this court would have to look to see if it's his sole or primary, the defendant's sole or primary defense, and then to evaluate also whether or not that evidence that was presented that goes to that affirmative defense could be characterized as weak. Is that fair? So to be fair.
Okay, so at least you acknowledge that there's some authority that says that it's not per se fundamental error.
I agree with that. I mean, I hate to say that on my client's behalf, but I think that's the reality of Florida law. I think that's a fair statement of what the reality of Florida law says. So let me go back to this trespass instruction. I want to be clear. The state is relying this morning on this trespass instruction. That instruction was given under a heading in the jury instruction that says trespass, and also that trespass is omitted from a consideration as the secondary offense in a burglary prosecution. I want to say also that I'm a little bit relying, and I have in my briefs as well, on the trespass instruction, and that the judge caught that, the trial court caught that, and said, I need to update that. And I think that's different from saying the defense counsel asked for it. The trial court caught that and kind of sua sponte said, I need to update that based on what we've heard from the defendant. But the same consideration, the same editing never occurred in the burglary context. And then I go back to the record itself on this entry. My client testified during his trial, and he said, that Rodriguez had told him the truck, that's where he'd be. And when I say I'm relying on pages 229 and then 243 to 44 of the trial transcript. So I think we have fundamental error on the face, and I think we have IAC on the face of the record. And for those reasons, I'm asking the court to reverse. Thank you.
Thank you both for your arguments. We have no other cases on the docket for this morning, so we are adjourned.
All rise.